they're essentially strangers.
Yeah, a bureaucrat hit the wrong button,
Yes.
basically, when entering the charges into the
Yes.
system. We're the Arms Attorneys. Today we're talking about what the FBI looks at to determine whether someone's disqualified when purchasing a firearm because they have a family violence misdemeanor conviction. Stick around to the end for our attorney pro tip on the most common way we see people unintentionally trigger this family violence prohibition. And before we get started, show your support for the Second Amendment by hitting the like button. So let's get started by talking about what a misdemeanor crime of family violence is under federal law for the purposes of who's disqualified for purchasing a firearm. And it's actually defined in 18 U.S.C. 921A33 as an offense that is a misdemeanor under federal, state, or tribal law and has as an element the use or attempted use of physical force or the threatened use of a deadly weapon committed by a current or former spouse, parent, or guardian of the victim, by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse, parent, or guardian, or by a person similarly situated to a spouse, parent, or guardian of the victim. So, really, what are we talking about here, Richard?
Yeah, so when the FBI is running a criminal history check, a lot of times they will look at, hey, what's the name of this crime? Assault, family violence, or battery of a spouse, or
domestic violence battery.
Domestic violence battery. They'll, a lot of crimes are titled in a way that makes it pretty obvious. Hey, this is a crime or misdemeanor crime of domestic violence because we have it in the title. But we see kind of a shift that happened in the mid-2000s that's really, the chickens are coming home to roost now. And what is that, Emily?
Yeah. And, I really saw this, I would say about 2016, 2017 is when the shift really started to take place, which is it used to be that if you were convicted of a crime called assault or battery, and it was a misdemeanor crime, when you went and filled out that 4473 and the FBI saw that, unless there was some sort of affirmative finding of family violence that had been entered, you were good. You could purchase that firearm. And now what we're seeing is the FBI really pulling back this curtain on who the victim in the case was, digging in. And if they find, it's a pretty common, I think, tactic by criminal defense attorneys. Let's say your client's accused of assault causing bodily injury, family violence, right, here in Texas.
Right.
And you don't want them to have that family violence crime. It used to be a very common tactic to say, okay, he'll plead to assault, just regular old assault, no family violence.
Drop the family violence finding.
Right. And that used to be like, okay, you are saving this guy's gun rights. There's also some other benefits that come from that, but saving the gun rights was a huge one. And now the way the FBI is looking at people's backgrounds, that's not happening anymore. So what we have is the FBI actually taking that crime, which is, assault, could be a bar fight for all they know, and looking to see who the victim was. If the victim was someone who qualifies under that definition, that's it. You have lost your gun rights under federal law. So it is really, really, it doesn't sound like a huge change, when you're sort of talking about the legalese of it. It's seismic in terms of who actually can purchase a firearm.
Right. And so what we see is they're peeling back the layers, looking at the crime itself, and does it have, there's really two key components to this. Is there an element of force and threatened force? So force, we all know what that means, some kind of physical exertion on another person, a restraint, punch, grab, tackle, we know what force is. And then they look at who is the force or threatened force, so it doesn't even have to be an exercise of force. Mm-hmm. If you threaten force, so force, threatened force, and then who is on the other side of the equation? And is it one of those people that Emily listed off? And if the answer to both of those questions is yes, the FBI is going to say, for purposes of 18 U.S.C. 922, you are convicted of a misdemeanor crime of domestic violence and therefore not eligible to purchase, possess, transfer firearms or ammunition for life. So it's a very serious, set of circumstances. In fact, I had a client who, when the police charged the case, they charged it wrong on the front end. He was charged with assault, causes bodily injury, family violence. And the person, the party that he allegedly assaulted, he didn't know the person, didn't even know their name. They never lived together. They were never dated. They're essentially strangers.
Yeah, a bureaucrat hit the wrong button, basically, when entering the charges into the system. Yeah.
And, and we were getting close to an agreement in this case, and it's one of those things where we had to put it on the record just because, the system is a nightmare. We had to put it on the record and make it very clear, hey, these two people are essentially strangers, because if anybody ever goes back and looks at this, incident, we want it to be very clear, crystal clear, that this was not a misdemeanor crime of domestic violence. And so we had to take those extra steps, but a lot of people don't think about that.
Right. And I think that brings us to our attorney pro tip of the day, which is the most common way we see people lose their gun rights for misdemeanor crimes of domestic violence. And it is those very low level, here in Texas, we call them Class C misdemeanors. They're called different things in different states.
Petty misdemeanors,
Yeah, like we're talking about your traffic ticket level offenses. Well, in most states, there is a crime for assault that is a traffic ticket level crime. It's generally yelling at somebody in a way that threatens them.
Simple assault.
Simple assault, which is unwanted touching. Like if you just shove somebody, that's simple assault. So I mean, it is really easy to do. It's easy to get charged, in a domestic violence sort of context. You're in a big fight with your husband or wife. Police get called out. They issue the Class C ticket. There's not even an arrest made. You walk into traffic court, essentially, and they say, okay, $100 fine, walk right back out. Have a good day. People do that because it seems like a speeding ticket. It seems like something they can, do without consequence. The consequences are huge. We see people who have lost their gun rights for life because they think they're basically just paying off a speeding ticket. So if you are ever charged in any way with, any sort of crime that involves force against one of these people we've mentioned, it is extraordinarily serious. Even if the court system isn't treating it as such, you need to contact a lawyer.
Exactly right. Well, we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment on the video below. I hope you can see by now we pull lots of our video ideas from what you guys want to hear about and from interesting topics you bring up. Until next time, we're the Armed Attorneys.